I've always understood it's not my case. Whoever the client is, it's their case. I serve at their pleasure. So I like to keep their pleasure high. And I really just apply the golden rule. If I'm a client, what would I want? I'd want no surprises. If you want me to review something, give me some time. Don't tell me it's due tomorrow at 10. Don't make any big decisions or commitments unless I'm in on it. It's my case, and so forth. And so I just apply that with the client, regardless of whether they're happened in the one instance to be the insurance company or self-insureds. They're going to know the case as it's going.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm thrilled to share part 2 of this conversation with Clem Glynn. As you were working to build a case to get it right, do you find that your firm is approached by certain carriers or certain companies or certain profiles, higher exposure types of cases?
We generally do not work for carriers. I have one exception, I can tell you about that, but throughout my career, it's primarily been self-insured. So DuPont was a huge client of mine for many years. They're still a client, but they've changed they've split off and done things. General Electric and other Fortune companies. So that was the beauty of Pillsbury. I got exposure to these firms and firms like that, and they had exposure to me. So when I say, hey, my rates are cheaper, and here I am with my own shingle, I had some credibility. We don't advertise. We don't do any of the stuff that lawyers do. Maybe we stay busy, so I guess it's working. I said I don't work for carriers. Most of us who deal with carriers understand they like premiums better than claims. And also, if you're dealing at the adjuster level, you're often dealing with somebody who's trying to impress somebody at the next level, who's trying to impress somebody. And you need to be at that upper level, right? Which is why you guys send your policy limits or time-limited demands so that you get the attention of the committee. And they do that. They respond to that. A guy that I used to work with at General Electric, great guy, he's one of my best friends in the profession, left GE, which has undergone its own dramatic changes. Several years ago, became a consultant to a particular insurance company. I won't name them, and they had a TBI case, and they didn't like the panel counsel they had. And he came to me and said, hey, we're really worried about this case. Could you guys help? And so we did. We got a good result for him. And then they said, well, we got another tough one. So that has kind of gone. And those tend to be higher exposure cases. In some of them, I'm the grandfather in the sense that there's a concept I never knew about called monitoring counsel, where I look over the shoulder of the lawyer doing the hard work and decide, do I have any thoughts? And in certain cases, do I need to say something to the insurance company like, you need to make a change? They usually are already at that point where they're concerned when they ask you to take a peek as monitoring counsel. But I like injury work, not because of any morbid sense, but it's, it's part of life. It's human dramas. It's pain. It's loss. It's, and I think being able to comprehend that and to show the appropriate reverence towards those episodes in people's lives is a useful thing. And there's lots of defense lawyers who are cynical as hell. Everybody's gaming the system. Every plaintiff's lawyer is just a scumbag who wants to make more money than the other plaintiff's lawyer that he wants to out-advertise, all that stuff. And then on the plaintiff side, everybody on the defense side is a, and numbnuts who, can't afford their car and, all that stuff goes on. And I don't think you ever maximize anything positive when you approach. If you don't let the stereotype you may start with get dislodged, let's say that. Casualty work, as I say, I think is they're also, they tend to be, you can get massive medical records and things like that, but they tend not to be these huge hundreds of thousands of pages of commercial documents and emails and all that. And that gets, I've done it many times, but they're a little bit more compact, even the big cases. And then the other thing is there's going to be an outcome in those cases. And one way or the other, most of them are going to get settled. Most of them aren't going to go to trial. And I think being able to participate in a solution is a gratifying thing. If you're positively participating. And then, of course, if you run up against somebody who is a little bit wacky in their evaluation from the plaintiff side, then you have to try the case, then you try the case. But I think even just providing a credible threat as a defendant, as a defense lawyer, makes a difference in case resolution. When I get a new case, if I'm defending, I always want to see who's the plaintiff's lawyer. It's the first thing I ask. Because you could take the same volume of clay as a sculptor, and there are ones who will turn it into an unbelievable work of art, and others who will just turn it into a bowl that can hold some Cheerios. And I want to know which sculptor I'm dealing with. So, and the same is true on the defense side, because the defense lawyer creates your risk if you're a plaintiff's lawyer. Facts are the facts, but okay. Now, what do we do with them? And I like being part of that process. And at this point, I think I've got a reasonable amount of street cred. And if I don't, I'm going to run out of runway pretty soon.
On the street cred side, when someone was asking a little bit about who you are, I was describing how there are people in this field who I sometimes would describe as a deep sea creature. Mm-hmm. There are whales in the law, and then there are the people that are beneath the whales, and monitoring counsel is the other phrase for them, which you don't even know that this person is shot calling in your case.
Yeah, right.
And yet there they are. On that front, or related front, you've talked a few different times, you used the word human and interactions. Can you outline some ways in which you feel that being a human and being a defense lawyer has made an impact? And
Yeah.
I'm thinking about meeting with a plaintiff at mediation or other situations like that.
One of my favorite instances of that was a case, very simple accident case. I was, Sears Roebuck was the defendant. One of their employees didn't T-bone, but sideswiped a car. And the case was assigned to somebody else, and in a panel lawyer somewhere, I'm sure. And the woman who was the driver of the other car started getting some neck pain. She went to Kaiser. Kaiser told her, well, you're going to need a neck surgery. And she said, no, thank you, and went home. And then she continued to get worsening neck pain. The old artificial whiplash, right? So she goes back, and they said, yeah, there's findings there. You need to deal with this. So she agrees to do the surgery and comes out of it hemiplegic on the left side. So now they figure it's a dangerous case, and they call me and say, we want you to try this but we'd like you to help us try to resolve it. So we go to mediation. It was my first involvement in the case, and wasn't a complex case. And she's there. 2 lawyers were there for her, good lawyers. Our mediator was Bill Bettinelli. I was there, but there was a pretty good number of people there. And Bettinelli starts the mediation. I thought it was a very clever way. He says, ma'am, we're going to be talking a lot about you today, but let's hear from you first. Tell us who you are. And her opening line was, who I am is not who I was. It was not rehearsed, 100% spontaneous in my view. And I knew the lawyers pretty well. They're not, architects, they're presenters. And she starts talking about her life story, and she grew up in the flats in Oakland, and she was, in kind of the deprived part of the town, and it was very important for her to escape the life and get out of that. And by the time of this accident, she was an investigator for the Alameda County District Attorney's Office dealing with welfare fraud. And as she's talking about her life and how she got to that point, she has this magical smile. There are more teeth than the average person, or at least more that showed up when she smiled. And she clearly enjoyed talking about that and her life. And then she started talking about how things are after the accident and the surgery. And pretty quickly into that phase of it, she started crying. And again, maybe she took me in, but I don't think so. I think it was real and it was spontaneous. And why not? Her life had been radically changed. So I don't know how long she spoke for. It was got a sense of who she was. A+ in front of a jury. Good Lord. I don't know if I mentioned she was an African-American woman. And I did mention the bad, she wanted to get out of the life. And her husband's there. And he was a janitor on the railroad cars. So she was the major breadwinner for the family. So Bettinelli turns to the plaintiff's lawyer, "You have anything you'd like to add?" "No, we're good." So then it's my turn. So I'd never met her. And I said, "Mrs. So-and-so, my name's Clem Glynn. I'm a lawyer. I'm representing Sears." I said, "Our driver was an idiot. We fired him. That doesn't do you any good. So I'm here for 2 reasons. The first reason is to see if I can help resolve the case. And I'm good at evaluating cases. I know, what we as lawyers do is try to figure out what's the risk in the case? What's it worth if it goes to a jury? And I'm pretty good at that." And I said, and the other thing is, if we can't get it done today and we have to go to trial, then I would try the case. And I'm pretty good at that. And I said, "I've watched you. And I can deal with your tears in the courtroom. And I've done that before, because tears are real and they have to be respected. But I'm okay with that." I said, "But I don't know how I'm going to deal with your smile." And I meant it, because she had this charismatic, wonderful, you could tell she was just a positive person. And then I started talking about, I've listened to you and I've learned something about who you are, even before today. And you've gotten a lousy deal here, but I'm not sure there's another person around who would continue to achieve despite that the way you will, in my opinion. And what you need is to get this behind you, feel like you're safe. And then I think you're going to really, you're going to do as well as anybody, given the hand you've been dealt. The whole time I'm talking, her husband is going, he's nodding. And you can see he knew I figured out his wife. And he liked me for it. And so we settled the case. I don't remember how much. And the lawyers, I was friendly with those lawyers from before, and they came up to me and said, "The first 10 minutes that you spoke, you settled the case. You validated her. She saw you were a human being, all that stuff." So I just think it's in the injury world, the demonization of plaintiffs and the demonization of plaintiffs' lawyers and the demonization of defense lawyers is kind of completely dysfunctional and beside the point. What you've got to do is you've got a human situation and you deal with it with some sensibility and civility and compassion. Does it show you're weak if you have compassion, or does it show you're strong? And that's why I told her what I told her, that, I'm not afraid to go to trial with you. I will go to trial with you if we have to, but we don't want to. And so I'm giving her both messages. I've said, when younger lawyers, they'll come in and, I'll just say, look, liability may be a stretch in this case. Okay. this person has suffered this injury. Think about it in terms of your family. That's your wife, your brother, your son, your sister. Think about it. Not, are you angry at somebody, but how is it going to change the family dynamic? That, there's a problem that wasn't there before. It's got to be dealt with. It changes everybody's lives who has contact with that person. So anyhow, I think that's one of the reasons I like personal injury cases. And as a result, I've made friends, in some cases close friends with, some of the really best of the plaintiffs' bar, because they know I'm not going to play the game.
Well, and I will say that it is both more enjoyable to practice with people who engage that way, the way that you're describing, and far more dangerous.
Mm-hmm.
The flat earth defense lawyer does not tend to do anywhere near as well as somebody who respects the person who's been hurt on the other side. If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law.
I tried a case of Martinez some years ago. The woman was a toll taker on the one of the Antioch Bridge, I think. And DuPont, who I mentioned was a good client of mine, had a pipe break and let a little chlorine leak out. And chlorine is heavy and it just doesn't diffuse right away. So the cloud reached her in her toll booth, and she sued, said she had horrible injuries to her airway. She was a fascinating case because we got all of her past medical records, and they were literally 5 feet high. Not from this episode per se, but from life. And she was a person who was low socioeconomic. She had, we're all amateur diagnosticians, right? But I think she had severe self-esteem problems. What particular axis she was on, I don't know. But she would find in comfort in doctors, these important, educated men usually, but women too, in her case, were paying attention to her. That made her feel good about herself. Yeah, it was really a tragic thing, because you'd see some minor presentation and it gets worse on the next report, and worse and worse and worse. So obviously it's a case in which if you release chlorine, even if whatever the case may be, it's a case where you're going to try to settle it. And we did. And we tried to settle it for significant payment. And her lawyer was, he was not somebody I made friends with.
Okay.
He was just like, everything was, traps and gotcha. And, so anyhow, we go out and tried the case. And I guess I should tell you one more fact that was a fascinating and lucky part of this case. Remember Sanders, who used to sit in Discovery in Contra Costa, Judy Sanders? So Discovery, when I got the case, again, long story, the Discovery was closed, and I saw a hole that hadn't been done. And in one of her affectations or symptoms was that she would talk to you and she'd say, "Mr. Cooper, good to meet you." And her voice would just go to a whisper. And because she had, as alleged, an airway injury that was devastating. And God, the legal system didn't treat her fairly. There was a doctor, a pulmonologist, he's very well known in asbestos circles, who had prescribed massive doses, retained by the plaintiff's lawyer, massive doses of prednisone. So massive that she was hospitalized with a psychotic break. And she had an embrittlement fracture on her foot, because as you probably know, prednisone will take your bones apart. And that didn't heal for a couple of years. She got it pinned, and she was just, and so anyhow, she was just being abused by this system that we work in, which the top plaintiffs' lawyers just don't do. They don't play it that way. They don't have to, but they don't play it that way. So I got Sanders because he'd played a game, and I pointed out the game he played, and so she got pissed, and she reopened discovery. And I had a guy named Dr. Herbert Dito, who's now dead, at UCSF. I got permission to have him do an examination of her vocal cords with a little camera while he tested her, and he videotaped her vocal cords as he tested her. And in the test, first thing he did is he had her read a simple paragraph. The red fox went over the green grass down the hill and came. So she read just like she talked. The next part of the test, they put earphones on and they give delayed audio feedback. So she's like a deaf person. She's not hearing real time, so she can't modulate her voice. The red fox went over the green hill and got the ball. Perfect.
Wow.
And each time you can see the vocal cords going and, all this stuff. And Dito was a character. I shouldn't and I won't in this. He had an alternative explanation for what had aggravated her throat. But he was a brilliant guy who had treated Pavarotti. He had invented procedures. He was legendary, but he was a character. Let's put it that way. So anyhow, we go to trial. We get a defense verdict. My goal was to beat the 998, and which was substantial. And we get a defense verdict. The jury just loved us, and among the feedback they gave us, was like a group of them stayed for well over an hour to talk. Nowadays, I don't know what your experience is, but a lot of times jurors just don't want to talk,
They do seem to drift off.
Yeah. And judges tell them, you don't have to talk to the lawyers, but if you want to, you can. And most of them say, I've watched them enough. But anyhow, this one juror says, we felt you were the only one in that courtroom who was looking out for her.
Interesting.
Because in closing argument, I said, she's been through hell, and she shouldn't have been, because the process has put her through hell, and she needs to get this closed. She needs to know she's okay, because what she had diagnosed was a somatoform disorder. You're saying to a woman, you're crazy? It's a dangerous defense, but medically it was there. You're hysterical and that kind of thing. And that was why the medical records were the way they were. Everything became bigger than it was. And it was tragic. It was tragic for her. But that, again, was a case where I was absolutely genuine in what I was telling the jury. And I was outraged by her lawyer and what the system had done to her, because she came out of it way worse than she went in. What she really needed was counseling. Somebody can work her through it. And I don't know enough about it to know what they do with somatoform. One funny, as trial lawyers, when we do mock juries and you see how the reasoning process of jurors sometimes is like, holy crap, that's scary. But we had Barbara Zuniga was our judge in this case, and she did the most thorough civil voir dire I've ever gone through. We took days to pick a civil jury. Days. Wow. If there was anybody with a cause thing, into chambers. She didn't want to cross-contaminate the jury.
Interesting.
Yeah. So it took a lot of time.
Yeah.
And nobody ever asked about, do you know anybody with a somatoform disorder? I can't remember exactly why. And when I'm talking to the same group of jurors afterwards, one of my biggest fans there, this one, you remind me of Tony La Russa, the way he manages the A's, the way you moved in the courtroom. It's like, okay. And so there's two women jurors together, and one says, she was like, pointing to the other juror, she was like an expert witness for you in the jury room. She has a sister with a somatoform disorder.
Oh, fascinating.
She was able to tell us all about it.
Oh, wow.
Talk about absolute blind luck, right?
Yeah.
What are the odds of that? But it was probably a big part of why we were able to convey that concept, because, you got somebody in the jury room saying, no, this is real. I've lived with it. I got a sister who does it. So
one of the things you mentioned is that most of your clients at this point, with the exception of that one carrier, are self-insured. How is it different in terms of the reporting, the information, the engagement that you do with that kind of a client?
Well, even with the insurance client, I said as a condition of me agreeing to work with them, I will not write those freaking monthly reports. I won't do all of I gave them a list of things I wouldn't do. Plus, I told them I wouldn't work for their rates. Because, in the role I'm in, because a lot of times we do take over cases, not just because, not monitoring, but we're asked, come in and take it over. This person is brain dead. And it's really fascinating because in the insurance defense bar, just my anecdotal observation, they range from really good trial lawyers and smart people to, are you kidding me? There's a whole segment of, are you kidding me? And this model that I've seen time and again, where some really junior lawyer or lawyers work the case up, and then the trial lawyer comes down from Mount Olympus to try the case. I can't do that. I got to be involved at every level. I want to see the witnesses and all that.
I'll push back on that for a second, because if you're taking over a case from somebody where the carrier has lost faith, that's even worse than getting it from a junior associate.
Oh, yeah. Yeah. I don't want to ever be understood, no matter who looks at this, as saying something that's a generalization applicable to all insurance defense lawyers. There's some terrific ones, but too often there's a model where the terrific ones are really not handling the case until the end, and I don't like that. So I don't do any of that stuff. And I tell them that one of the reasons I won't do it is not because I'm a prima donna, but we're real-time reporters. I've always understood it's not my case. Whoever the client is, it's their case. I serve at their pleasure. So I like to keep their pleasure high. And I really just apply the golden rule. If I'm a client, what would I want? And I'd want no surprises. If you want me to review something, give me some time. Don't tell me it's due tomorrow at 10. Don't make any big decisions or commitments unless I'm in on it. It's my case, and so forth. And so I just apply that with the client, regardless of whether they're happened in the one instance to be the insurance company or self-insureds. They're going to know the case as it's going. And with email, of course, it's simple to do that. You BC them on a communication of the case, whatever. You're able to give them, and nobody's ever pushed back and said too much. Don't just call me when there's a decision to be made. People like to know what's going on in their case. Putting it a different way, it's astonishing, even to this day, how many lawyers think I'm in charge, leave me alone. You can't do that. The client is king, queen, emperor, whatever, and you let them tell you too much. If they do, then okay, then you modify it. But my default position is I want them involved in case decisions, et cetera. And it may be that any given client doesn't have the sophistication to make the judgments that you have to make, but you still, as a lawyer, can explain it. And say, this, we could do A, B, or C. Here, I recommend C. Here's why. Are you good with that? That's okay. I think it's the same regardless of whether they're a carrier or not. It's just that the carriers themselves are institutionally incapable of agreeing with people like me, except this one carrier has done it. And so I keep working. The other thing is if they keep turning the robot loose on my bills so that they disallow that kind of crap. And then I have to appeal. And I've never lost a penny because every appeal, I go to the lawyer, the adjuster, and I say, hey, would you just tell them to approve this? And they approve it. And this is crap. I don't want to spend my days doing that or have my staff do that. It's just so wasteful. Time, value, and money.
Thank you for listening. And please join us next week as we continue this conversation. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.